Good morning, everyone, and welcome to MacroPro and Friends. We're delighted to be here with you. I'm Diane Cohen, and I'm joined by my colleague, Drew Davis. Hi, Drew. How are you?
I'm great, Diane. How are you doing?
I'm doing good. I really miss seeing you and all the team and everybody out in the field. It's really a very different experience.
Same here. Same here. I definitely miss everyone too.
Yeah, it is kind of different. Well, today we're going to be talking about what direction people's claims are going. We have a really great program. So I just think it's kind of interesting what's going on in the world and what's happening.
Exactly. I mean, there are so many employers right now trying to figure out what's going on, especially with this new presumption of readiness, relatedness, I mean, with Governor Gavin Newsom and the risk for employers to open up their businesses and the spread of COVID. So it's great that we have some great speakers today to talk about COVID-19 and what to expect in the future.
Yeah, James and Liz have a lot of information to share with us today. It's going to be jam-packed regarding that. So I'm looking forward to that aspect.
Sure is. It sure is. Very exciting.
Talk about.
Well, let's talk a little bit about our webinars. We want to let all of our wonderful clients know that if they're looking for CEU credits, MacroPro is there to provide them. We have a list of topics that we already have approved that we're happy to provide. But we also want to let everyone know that if they have a specific topic or an expert that they're looking for, to please let us know. And Diane and I will do everything possible to secure it. And we also wanted to talk about our YouTube channel that MacroPro now has. And Diane, you've been doing a lot with that and doing interviews. Maybe you'd like to talk about it a little bit.
Yeah, well, you know, it's something new that we've done, COVID-19, reach out to our clients and provide some content in different ways. So we have something called online chats, and the idea of online chats is to provide information, speaking with litigation and claims experts, giving ideas that can be shared, you know, nationwide. People, you know, in New York may have a great program that might benefit somebody in Arizona, for example. And so we are doing online chats, and it's a great program, and they can find that on the MacroPro YouTube channel. So we look forward to having information for you there.
And I see that one of your most recent interviews was Stacy Caldwell, the leader of BBSI. That was a great interview with a lot of information for our listeners to utilize.
Yeah, she was really great. She was a wonderful program that anybody who heads up a claims department and program, you know, should listen to, because she has some great ideas.
Absolutely. And again, for all of our listeners, I did talk about the CEUs that we can provide. This is a great visual flyer here for you to look at, but please note you can also reach out to us if there's anything specific or a specific topic that you'd like.
So I just wanted to let you know that we are going to be providing a CEU for this event. And so it is important that you check your email. You should be getting it tomorrow, and it should look something like this. You'll see that it says My Certificate, and you want to download that. Since we cannot verify the amount of time that somebody stays on the webinar, we can't send it out to individuals. It is all done automatically by GoToWebinar. So please make sure you check your emails and you download that for your records. So Drew, I think it is time for us to talk a little bit about getting records, and then we'll get on to our speakers. So because of COVID-19, people need to be aware that things have changed. We have only about 75% of our custodians that are open, so the turnaround times obviously are going to be slower. Now, this is far better than it was when COVID originally hit. We were looking at 25%, then it moved up, and now we're at 75%. So we're getting a great deal of records for our clients. Just know that the turnaround times are not going to be what they were post or pre-COVID. To expedite orders, we should be ordering online. And I look like I'm frozen, but maybe not. Anyway, so to expedite orders, you should be online and order that way. We have 3 shifts in our production department that will be running in order to get you your records. And so our people are working from 3 a.m. until midnight in order to ensure that you get those records. And then the safest way to get records is to download the records. So you can get them in any format you want, but really a download would be the best. So I'd like to introduce to everybody to our speakers today. So if our speakers would please come up. All right, so we're gonna have a great program today. Our first speaker is Shandon Jones, and she's with Authenticate 4. Then we have Elizabeth Ewer, James Rossi, and then our own Graciela Ojeda from MacroPro. So thank you all for being with us today and sharing some great information. We really appreciate you being here. So we're going to start with Shandin. And Graciela, thank you so much for being our moderator and asking questions when that comes up. So Shandin, we really appreciate you being here. I know your program is really interesting, and I really feel that it's going to benefit the workers' compensation community greatly. This really is going to reduce the amount of fraud when it comes to claims, because people are really going to be able to see whether or not the injury is truly there, or if it's something that maybe is a misread on a film. So I will talk to you later. Have a great program.
Thank you so much, Diane. Yeah, you're absolutely right. I'm so excited to be here today. So thank you first and foremost for inviting us to join MacroPro and Friends for this wonderful CEU. I have quite a few slides, but I promise you I will zip through them and make sure to keep this right in the 20 to 25 minute range. So as Diane said, I'm Shandin Jones with Authentic 4D, and today I'm going to really focus on the 4D category as it relates to claims in the claims industry and how beneficial it is for resolving claims. Before I begin, I'm going to talk a little bit about my background. I've been with Authentic for about a little over a year. Prior to that, I was with a large ancillary provider in the workers' compensation space for about 17 years, or almost 17 years. And prior to that, I was an adjuster for 8 years. So I'm actually just probably reflecting how old I am, but have been in the insurance industry for quite some time. And as an adjuster, this is absolutely the tool that I wish that I would have had available to me. So before we get into the 4D category, I'm just going to share a little bit about Authentic 4D. Authentic 4D is really a program and a service designed to help you resolve claims quicker and with much less expense. 85% of the time, a subspecialized radiologist, whether it's our radiologist, our subspecialized radiologist, or another subspecialized radiologist, can tell you whether or not an injury is legitimate, meaning it's traumatically induced, acute, tied to a date of an injury, versus something that's degenerative, chronic, pre-existing, and not tied to a date of injury. So I'm going to walk you through kind of what the 4D category does and how it will benefit you tremendously. So let's go ahead and get started. The 4D category is all about really review and resolve. It's typically a network of subspecialized radiologists all across the country, licensed in all the various states so they can perform the reviews. They help you to confirm injuries faster, direct appropriate treatment, and then just resolve things that are pre-existing, degenerate, and are not necessarily tied to a date of injury. Overall, this really helps to reduce the claims cycle time, and we'll talk a little bit more about that as we move forward. A little bit of background on Authentic 4D. We've been around for about 10 years. We have $20 million invested into the platform. We use a patented technology to provide the visual effects of what we do. And of course, it's all FDA approved software. We started in the surgical pre-planning space, and even today we have many different surgeons across the country. In fact, one of our top surgeons that utilizes our software for surgery and spatial acuity prior to surgery, they still utilize our software today. So we essentially sort of pivoted and found a very unique need in the claims world, and that's really across all claims, all casualty claims, personal lines, auto, GL, and workers' compensation. So what claims are applicable for 4D review? Well, it's really any diagnostic imaging, any MRI, CT, and even x-rays. And it's things like disc bulges, herniations, rotator cuff tears, traumatic brain injuries. I'm going to show you an example of that later on here in the presentation. But really, it's designed to help reduce unnecessary expenses, such as surgeries, treatment, PT, chiropractic care, even litigation. It really helps to help you know whether or not an injury is legitimate early on and get that person the appropriate care they need, or know that this is not a legitimate injury. It's something that's pre-existing, chronic in nature, and not part of a workers' compensation claim. You know, with the COVID-19 and that situation where IMEs are really sort of on delay, we've been an excellent resource for adjusters to be able to really truly understand whether or not it's a legitimate injury versus something that is maybe pre-existing or degenerative. Again, we just help to close files faster, get more appropriate, accurate treatment. Pay what you owe is a big part of this. You want to make sure that you're paying the appropriate amount for various claims, and then helping to suppress indemnity on pre-existing claims. So by and large, an MRI is a very much objective test. However, when it comes to the interpretations, it's very much subjective. This is a study that was sponsored by HSS, Hospital of Special Surgery, and it essentially was a patient that was scanned at 10 different diagnostic facilities across in an area in New York. And then after the scans, all of the reports were reviewed, and it was determined that there was a 40% variability rate with their interpretations. So when you think about that in terms of the decisions that are being made by adjusters on claims, whether it's treatment or surgeries, et cetera, based on diagnostic reports, it's imperative to make sure that you have the appropriate person reviewing your diagnostic imaging and making those interpretations. Life of an injury claim, there's definitely a cost to waiting. The average cost of a claim, our data suggests it's anywhere from $3,500 to $7,000 per month. It's for things like treatment that's going up, time loss, litigation costs. All of that adds up and creates, you know, an urgency in the sense of trying to make sure and resolve the claim as quickly as possible. So in terms of the 4D category, these are really 4 key components to any 4D provider that they should really have as key pillars to their service. The first one being that it's very fast, within 48 hours. At least I can't speak for other providers, but for Authentic 4D, we're able to advise you as to whether or not something's legitimate or if it's chronic, degenerative, et cetera. It's extremely economical. It's $200 to have us do the review and render the verbal or oral results. It's extremely objective. We'll talk a little bit more about the network specifically, but they're subspecialized, which means that they're highly trained radiologists. They're extremely expert in their field. And then we also do blinded reads. They don't know who they're reading for, and we'll talk a little bit more about that. And then, of course, the visual aspect of what we do. So we take the expert radiologist's opinion and then combine that with a visual platform, or it's essentially a 90-second, 120-second video of the visual tour of the patient's actual MRI. So I'll show you a couple examples of that. But the combination of these 4 key pillars is what really makes this program and service compelling. So the radiologist's facts in terms of a 4D provider. As I mentioned before, they're subspecialized radiologists. They're either musculoskeletal radiologists or neuroradiologists. At least in terms of our network, they are all US based. They're all American board certified, and these are things that you should definitely make sure to have in terms of a subspecialized network. 90% of the work must be clinical in nature and outside of the insurance space. So, for example, our radiologist at Authentic 4D are radiologists who work for prestigious institutions such as Harvard, Stanford, UCLA, New York Presbyterian. So we require that most of what they do is outside of the insurance space, further helping to make sure that our work product and the reviews that they provide are very objective. They are all willing and able to testify. And of course, we assign them by geography and their licensure, of course. As I mentioned before, the studies are read blindly, so they're not privy to whether or not it's a defense or a plaintiff attorney. And believe it or not, for Authentic 4D at least, we actually do some plaintiff work. It's not a ton, but we embrace that because it further lends to our objectivity. So here's another clinical study, just the importance of a second opinion by a subspecialized radiologist. In this study, there were 153 patients that got both a general radiologist opinion and a second subspecialized opinion. Upon completing the reviews, there was disagreement found in 38% of the 153 cases, or in 58 cases. Of that, the second opinion interpretations affected treatment 25% of the time, or in 38 cases. 76% of the cases with the disagreement, the second opinion was proven to be more accurate based on the histopathology. So they actually used tissue samples, et cetera, to actually prove it out. So the discordant interpretations of MRI exams, it has a substantial effect on the clinical management of claims. I like to show this slide too because this is a little bit more unique and specific to Authentic 4D, but I think it highlights the need to make sure that there is quality weaved into radiology reviews and interpretations. So we take a great amount of pride in ensuring quality assurance. And to give you perspective on that, the average hospital rereads about 1% of their MRIs, meaning they have another clinician come in, review the films, review the report to assess how accurate it was. When you get into a specialized hospital, such as HSS or others, they might do this particular exercise at about 5% of the time. We at Authentic 4D do this 25% of the time. And so when our radiologists are not doing reviews that have come in from prospective clients, we are paying them to review other radiologists' work to ensure the highest quality of work is achieved. Something else I like to point out here, and not picking on any diagnostic ancillary network, but diagnostic ancillary providers in the workers' comp space, they credential about every 2 to 3 years, approximately. Everyone might be a little bit different. But what that means is that they're reviewing radiologist licenses, malpractice insurance, and maybe the facility accreditation. They're not actually doing rereads looking at the work for quality. So just keep that in mind. So let's talk about the 4D process a little bit. How does it work? We start by doing a verbal medical review. So once we receive the films, the report, and a claims background form, it's a small form, I'll show you that in a little bit, just provides you a little bit of demographic information on the person that we're doing the review for. Once we receive those 3 things, we then push them out to our subspecialized radiologists. And I can't speak for other 4D networks, but this is essentially how the 4D category goes. So they have about 48 hours in which they review it, and then they provide back their opinion. They provide us an unsigned medical report. We then deliver that information orally or verbally over the phone to the adjuster, attorney, nurse, whomever the stakeholder might be. This helps to really facilitate, early resolution, because you're essentially understanding the legitimacy of the claim early on. And again, this helps because it's also very quick, especially with COVID and IMEs being delayed for weeks and months. We can look at these things virtually, and there's no delay while the patient's getting time loss. It's $200, and as I mentioned, the review is completed within 48 hours. We will send a calendar link to the stakeholder, whomever that may be, the adjuster, attorney, nurse. They actually look at the calendar and then choose a time that works best for them to participate in the verbal medical review. It takes about 5 to 10 minutes, maybe 15 minutes if there's question. but we always do that first so that we don't provide anything necessarily in writing unless you would like us to. We can go directly to the report and bypass the verbal medical review, but many times people want to understand what they're dealing with in terms of the legitimacy of the injury before having something sent to them in writing. So this is our standard process. Of course, we can customize it a little bit based on what folks need. Our written report, this is an example of it. Of course, after the verbal medical review, if it's determined that, and we recommend a written report, we then will provide you with this, and we summarize it. You'll see it at the bottom in green. We'll provide a very easy summary. So any layperson without the 8 to 10 years of requisite medical training can easily understand this. It just highlights the key points. We also have a visual report. It's essentially the written report plus 2 still images, extremely compelling, highlights using arrows annotations as to whether or not something is acute or chronic, etc. And again, the written report is going to have the summary with it as well. And then we get to our video report. The video report is really reserved for things that are clear-cut exaggerations, errors, where original radiologists, general radiologists typically are calling out things that maybe don't exist, or they're just errors in what they're seeing or interpreting. I mentioned before, it's about a 120-second visual tour of the patient's actual MRI. And then what we will do is a triple comparison. So especially in the situation where there is not a pre-date of loss scan, which is about 95% of the time, we are able to do a triple comparison where we take somebody in the same age category that is in a healthy state, and then somebody with the alleged injury. And of course, these are anonymized exemplars. And then we do a triple comparison. So I'll show you that in just a few minutes. We also will render the films in 3D, which we really feel like is the CSI factor of all of this. And then of course, we provide the written medical report and affidavit. The fee for that is $1,300. And if needed for a couple $100 more, we're able to actually have the subspecialized radiologist do a voice narration or a voice over on it, walking you through the various elements of that specific patient. This is an example of the affidavit that comes with the video report. And of course, this just demonstrates to the other side that you're really willing to go the distance if needed. So this is just a recap kind of our fee structure. Again, I can't speak to other 40 providers, but again, we start out with the verbal medical review. That's $200. The written report by itself is $650. If you bypass the verbal medical review, that is $500 for the written report. Some of our clients do that as well. And then the visual with the 2 still images and the video report that has the affidavit and the still images. So before we get into the videos, I'll just maybe highlight, most of us as humans are visual learners, and I really don't have to belabor this. There's studies that go back to the 1950s that talk about that. With the invent of the internet and smartphones and YouTube, etc., visually, we are all very much visual learners. So let's get into some video examples here. I have 3, and the first one I'm going to show you is a broad-based disc herniation. The second one is a traumatic brain injury, and the third, permitting time, is an annular tear. So let's just jump right in. Here's an example of our video report. I'm going to go ahead and hit play. You'll see in the green, that is the unremarkable exemplar, and then in the red is somebody with the actual alleged injury that the patient is claiming. In this specific case, and this is one where we actually reviewed it, and I should just stop here for a second. With each video, we always do a glossary review of the anatomy. And so that just kind of sets a clinical stage for anyone that's viewing it, whether it be an ALJ, an attorney, a nurse, etc., or, a jury if it's in the auto work comp field. So I'm going to fast forward here. So this is the actual triple comparison. So the injured worker is actually in the middle, and then we have unremarkable in green and somebody with the actual alleged injury in red. So you can see the highlights, the arrows and annotations that are highlighting that this specific patient doesn't have the actual injury that they're alleging or that was called out by the radiologist. I'm going to pause it there for a second. And then we'll use these arrows and annotations to point out why specifically. So if this patient did have the broad-based disc herniation, this is what it would look like. The top view is a sagittal view, so that's a sideways view. The bottom view is the axial view. That's picture standing on top of a ladder looking down at the spine. The axial view is typically the view that radiologists and clinicians rely on most. So we'll just go ahead and keep moving through the video here. Now this is actually what I call our CSI factor. This is the 3D view that we render, and it's extremely compelling. I'm just going to go ahead and hit play and let you watch it for yourself. So with 3D, we can actually take the patient's scan and we juxtapose it next to the patient next to the person that has the alleged injury, and you can actually see, we can rotate it, twist it, turn it around. And so you can see what it would look like had this person actually had a broad-based disc herniation. You know, maybe at most they have a mild bulge, but you can see here, there's really no disruption in the spinal canal. So we'll just go ahead and keep going. We're almost done with this one. And here is a traumatic brain injury. So same thing, we'll do the comparisons. We always start with a glossary view of the anatomy. And so with the TBIs, we will, and let me pause it for 1 second. We initially will compare it next to an unremarkable, and then we'll bring in somebody that is in an acute exemplar. In this case, it was called out that there was a contusion and a midline ventricular shift. So we're going to show you both of those as it compares to both, but the injury doesn't exist. So we'll go ahead and hit play. The middle view here, this little box, that is a 3D reference. So that's sort of the CSI factor when it comes to a TBI. So you can see here with the acute exemplar, the hypointensity signals, that is a contusion. And that's what a contusion looks like on an MRI. And you can see in blue, the patient does not have that. Same thing with the midline ventricular shift. So it's extremely compelling. And in the reference view, you can see where it's at actually in the brain. And that was a hemorrhage, of course. We'll just go ahead and fast forward that. And then at the very end, we'll do a triple comparison on this. Same as what we did in the others. All right, in the sake of time, I'm gonna speed through this. Here's a situation where a patient actually had an L5S1 fusion. 2 years later, they came back and the original radiologist that saw the film said there's now an annular tear. So you can see the mess that this patient has with all the hardware in their spine. And so this is the actual video where we reviewed it and basically indicated that there is not an annular tear. So I'm going to fast forward through all the clinical stuff here. So you can see in the far right in red, if there was an annular tear, that's what it would look like. There's hypointensity signal that comes out on any diagnostic film that shows you that. And so then we're using arrows and annotations to point out that doesn't exist. Additionally, this patient has a lot of degenerative changes up the spine, so it's consistent with, you know, degeneration essentially. And then of course, this is the axial view that we can show the same thing. So that's the top-down view in the box. All right, so I'm going to keep going here for the sake of time. I know we're getting close. So admissibility, inevitably, this always comes up. People always want to understand admissibility. Is this admissible? 100%. We have 100% track record. We use FDA cleared technology for this. All of our video reports come with an affidavit, and then there, of course, there's our radiologists are willing and able to testify. Although what I would tell you is only about 1 in 3,000 to 4,000 actually goes to trial when this is used, because this is so compelling that most any stakeholders in this understand that this really helps to suppress indemnity, really reflect the truth about a claim. Drawings and skeletons have been used for decades in courtrooms, and so this is really no different than that, although what I would say is probably a little bit more authentic, and I know that sounds cheesy and I'm not trying to be, but it's essentially the patient's, their own MRI that we're comparing it and juxtaposing other exemplars with the alleged injury, or one's in a healthy state. A lot of times attorneys will wheel in skeletons and illustrations and they dramatize them. As you can see, the picture in the bottom left, they sort of highlight it in red and make it look way worse than it actually is. So reporting and best practices. I like to show this because it really demonstrates the ROI when using a 4D provider. This particular customer wanted to understand better what their ROI with us was. So they sent us 1,600 files to review. They wanted to do a deeper dive into that. So of the 1,600 files, we initially broke it down by agree, disagree, whether we agreed with the original radiologist or we disagreed with the original radiologist. And you can see there's about a 15% indeterminate rate there. And that just is typically because the films are not of high quality. Maybe it was done on an open and they're grainy, et cetera. We just can't tell. Or the scan was done, say, too far post date of injury to understand whether or not we could tie that to the date of injury or date of loss. So in this particular case, you can see there was about 700 that we agreed with, 700 and some that we disagreed with. So it's about a 50-50 split. From there, they added up everything that they spent. You can see what they purchased from us. It was about $800,000. And then they did a deeper dive on 13 files of the 704 where we disagreed with the original radiologist. So of those cases, they did a deeper dive and found that about $1.2 million was attributed in savings to the settlement benefit, and about $210,000 to avoiding, reduction of expenses, which would be like avoiding IMEs and litigation expenses. So huge ROI. That was only 13 files on 700 and some. I can't speak for other 4D category companies, vendors, but for us, we provide sample reporting that allows our clients to trend the providers at the treating facility level, also at the original radiologist level. So we do a reporting that actually shows you an agree, disagree, and that just allows you to trend it. And especially in work comp where you can direct care, you can start to direct around those facilities that maybe there's some not so good apples there. So 3 easy steps I mentioned before. We just need the images. We need the diagnostic medical report and a claims background form. I already kind of talked about this a little bit. For us, it's about 48 hours, $200, and we render the verbal medical review. Again, that just kind of outlines that. I'm kind of blowing through this for the sake of time because I know we're getting close. But you can initiate the referral by working through your records retrieval partner or through us. In this case, we do have a partnership with MacroPro, a great partnership. So together we can help retrieve the films and then provide the review for you. So we're almost on the home stretch here. When should a 4D referral be considered? I'm not going to read all of these, but a few that come to mind are really when there's a disagreement amongst clinicians. So if you've got a treating doctor and a radiologist not agreeing on things. It can also be when a radiology report is driving the treatment and care and surgery, and you want to take another look at this. For how inexpensive it is and for how much a surgery costs, it is well worth it to make sure that you're paying for something that is tied to a date of injury or the work comp claim. So we kind of talked about this a little bit too. Best practices, really just partner with your records retrieval companies such as MacroPro. And again, we have a partnership with them. It's definitely a time saver. We actually recommend that you send as many cases to us as possible because the ROI is so significant, and the cost for us to review it, the $200 is so minimal compared to the savings on what you'll save on avoided surgeries and treatment, avoided IMEs, avoided litigation costs. So I highly encourage you to reach out to me if you'd like more information, or if you would like to talk about maybe setting up a pilot with Authentic 4D. That is it for me. Thank you again so much for your time and attention. If there's any questions, I'd be happy to field them now.
Thank you so much, Hendon. That was a great presentation. And there is a question. What percentage of the cases that you review are inaccurate or contain errors?
Oh, perfect. Thank you for that question. That's great. So we see it's about a 50-50 split, similar to what you may recall with that client's own analysis that they did. It's right around the 60-40 or 50-50, which means 40 to 50% of the diagnostics that your adjusters are making critical decisions on could be erroneous, and likely are erroneous. So thank you.
Thank you. That's the only question.
Perfect.
Thank you, Shandon. It's, I think, very fascinating to be able to watch those films that you were showing us and to be able to see what the difference is. It's just such concrete evidence, and at such a fraction of a cost of litigation, and just the fact that you're paying TD for long term while you're trying to determine something. So thank you. I'd like you to stay on. Graciela, stay on. Thank you for your question, as we're going to get some final thoughts from you. But now one of my favorite law firms are showing up, the Rossi Law Group. I've known James for a little while and instantly liked him. He's good people, as is Elizabeth. You work from his office. So you guys are going to talk to us a little bit about COVID today, or shall I say a lot about COVID. So I'm going to go ahead and let you guys get started. And just as a reminder to everybody, the handouts are attached to this webinar, so please download it. And if you have any questions, there is a question box. You're welcome to utilize that. And if time permits, we'll be happy to ask those questions. All right, James, Elizabeth, thank you for being with us today.
Thank you, Diane.
Thank you.
So I'm James Rossi of Rossi Law Group. I'm the president and managing attorney of the firm. And Elizabeth is the managing attorney in our Ontario office. We serve basically the bottom third of the state, and pretty much that entire area. And so today we're going to talk about COVID-19 and a claims update. But before I get going, I just want to give a disclaimer that the opinions herein are the opinions of RLG. It shouldn't be applied to any specific case. If you have a case, you should apply the facts of that case to the law. Seek legal counsel where necessary. So get that out of the way. Secondly, I want to thank the wonderful Diane Cohen and MacroPro and Friends for having us today. It's very impressive, the operation they have and how they put this all together. I got to say, I'm pretty blown away by it. So I want to say thank you very much for having us. And then I want to thank everybody for attending, because I know there are other things you could be doing, maybe things better than talking about COVID-19 and workers' comp, but that's our job and that's what we're here for. And I know there's a lot of confusion going on. There's a lot of information that we need to digest. And so today we're going to help you digest some of that. I'm going to start this with a couple of hypotheticals. And if you want to write them down, do it, because we're going to refer to these throughout. Let's start with a grocery store worker who contracts COVID-19 outside of work, resulting in a positive test in April 2020, 2 days after his last day of work. He got it from a family member who got the whole household sick with COVID-19. It's non-industrial. Then we're going to have a second hypothetical, which is the same grocery store worker, but in this case, we don't know where it was contracted, and all the other facts are the same. And so we have no family member that tested positive or anything like that. So just keep those two hypotheticals in mind, because I think at the end of the day, when this is over, it'll help you understand how the presumption we're going to be talking about applies, as well as how it could be in the future. So let's get started with the next slide. The topics we're going to hit are causation. That's going to be a discussion about essentially how we look at these types of cases, non-occupational diseases. Assume there's no presumption. This is how it would work. And there isn't a presumption in some of the dates of injury already. So we'll touch on that. Then we're going to go into the governor's order, which Liz is going to cover. And that's where there's a presumption of work-relatedness that was issued by Governor Gavin Newsom. And then lastly, we're just going to briefly touch on some of the proposed legislation to give you an idea of how crazy it could be. So causation. Now, non-occupational diseases, such as the flu and the cold, are generally non-industrial. COVID-19 obviously would fall into this category. There is an exception, though. It's the special exposure exception. And it's when there is the employment creates a materially greater risk of contracting the disease than it would to the general public. And so we have to do that kind of an analysis. Now, typically, it's the applicant's burden of proof. And so if the applicant can show that they got it at work because there was a bigger risk at work, then they can show it's compensable. But it is their burden. So if you don't have a clue where it was contracted, then the applicant loses. So presumptions come in and are a very big role in all that. To give you an idea, though, because this is so new, you're not going to be able to find examples of COVID-19 claims and how it all works. Most of you probably haven't even seen one. We've been seeing them here and there. We've got a few that we're handling, but it hasn't blown up by any means. But it's gonna. I'm going to cover valley fever claims because it'll give you an idea of how the analysis works. So valley fever is it's a disease that you get when you contract these spores. These spores are in the ground in certain endemic areas. For example, Bakersfield to Fresno is an endemic area. And so people that live in Bakersfield and Fresno are exposed to these spores and they can breathe them in, and then they get immunities, or they get sick, or anywhere along a spectrum. It could be they have no symptoms at all the way to death. And so basically these spores are released in the ground, and then people breathe them in. People that live there, they don't get sick. Almost nobody gets sick. They have an immunity to it. It's not a big deal. But sometimes they do get sick. And so we see claims where they allege that it's work-related. For example, I've had a number of them in the farms where they're outdoor working. They maybe do digging, things of that nature. They filed a claim. They say they were at a greater risk than the general population who's not outside digging in the dirt in farms. And so they therefore make a claim. So what we've got to do is we've got to evaluate other potential causes that could have caused the COVID or the valley fever. And in that instance, I'm not quite there yet. And in that instance, for example, I had a case where a farm laborer was alleging that he got valley fever, was breathing in the spores from work, digging in the fields, etc. And so what we did was we go to MapQuest, we look and see, or Google Earth, and we look and see what's around. Does he live near a farm? Was there construction going on? Things of that nature. So in this particular case, we didn't see any of that, but it was pretty close to the Bakersfield board. And so I stopped by when I was on another case, and I saw a major construction project. It turns, we had a law clerk who was able to uncover that during the relevant time period for contracting the disease, it was full-fledged going, major lane addition, on-ramp, and it was only about 200 yards from the applicant's home. So the doctor who had indicated it was work-related, once he got that information, he said, okay, I can't say with a reasonable medical probability that it was contracted at work versus the construction, because there's a lot of literature that construction can result in it when there's digging. So that was an example where we were able to defeat it when the cards were against us. Then there's another case where I think it was work-related, where, for example, you got an LA-based person who, LA is not endemic. We don't have valley fever very often. It's very uncommon. this particular worker spent 2 weeks working in Bakersfield and then got sick. We couldn't point to anything, construction, nothing was available to us other than the fact that he was in Bakersfield. So the doctor said that with a reasonable degree of medical certainty, it's work-related. So that's how this analysis works. So with COVID, it's going to be a similar type of thing. And now we're ready for the next slide. These are the kinds of questions that we'll ask. Whether people they live with had COVID-19. Now remember, in the hypothetical I gave you in the first one, we've got someone who in fact got it from his family. So that's why you got to ask those types of questions. Whether they are following social distancing. This is becoming a big issue right now because we're having a lot of protests with thousands of people that are all gathering, side by side. We're going to have presidential rallies coming up. People are going back to church. Some people just don't wear masks no matter what. It's really unknown how it's going to go, but we have to look at the social distancing aspect. The next one is, what kind of work do they do? Do they have any other jobs? So maybe it's an office worker who also works in a grocery store. So who would be liable there? Whether family, friends, girlfriends, or anyone outside of work exposed the injured worker. That's really what it all comes down to. That's the general thing we're trying to find. Whether other employees had it is a big one. The type of work and exposure to the public, a grocery store worker versus someone who works in an office, like the few people in our office that are not working in the home. We have about 7 people and they don't interact with anybody in an 8,000 square foot facility. So they are at a very low risk. I would say they're at a greater risk going to the grocery store or something else. Then whether the type and exposure, what is the type of work and exposure to the public? And then lastly, whether they live in a hot spot. Obviously, if you live in Ventura County, it's not a hot spot, but if you live in LA County, downtown LA, and then you work in Ventura County, well, you're more likely to get it in the downtown LA area. So we're going to look at these types of questions so that we can show that it's not work related. So then the governor came by and issued an order on May 6th, and he changed the analysis. He said it's no longer the burden of the applicant to prove COVID-19 if they are working when they got it. And so now all of a sudden it puts it on to us to have to actually show where they actually got it. That's a big deal. That's a hard thing to do. And I think what you're going to see is about 95% of these are going to be compensable. It's going to be something overwhelming like that during the period of the order. And the thing that shows that the standard is, as I was talking about for non-occupational diseases, will be applicable is the order itself specifically states, whereas employees who report to their places of employment are exposed to an increased risk of contracting COVID-19. So it's one of the bases for the order. And so now what we're going to do is we're going to talk about the order. Liz is going to go through the presumption, the elements, things of that nature, and get you up to speed so you know what it is you're looking for.
All right, thanks, James. Let's dive into the elements that need to be satisfied for the presumption to apply. There are 4 elements, and you have to satisfy all of them, which means that if any of these 4 elements does not apply or is not satisfied, you don't have a presumption, which doesn't necessarily mean that the COVID-19 is non-industrial. It just means that you apply the normal AOE-COE analysis. So let's start with the first element here. It's that the injured worker is either diagnosed with COVID-19 or test positive for COVID-19 within 14 days after that injured worker performed labor or services at the employer's place of business at the employer's direction. So how do we decide if this applies? Well, first you look at the date of the diagnosis or positive test, go back 14 days, and determine whether or not the injured worker actually worked for the employer at their place of business at the employer's direction. Now, the part that's a little bit vague here is at the employer's direction. What does that actually mean? And unfortunately, we don't have an extremely clear answer. There are a few scenarios that are a little bit more clear-cut. Two of those I'll talk about right now. The first is pretty easy and is likely to apply to a lot of the claims. This is a scenario where you have an employee that is sent to their employer's place of business, scheduled by the employer, told to show up. That, in my opinion, is clearly at the employer's direction. Another scenario that's pretty easy as well is if you have an employer who tells their employee, do not show up to work. That's pretty clear that if that employee does show up to work, it's not at the employer's direction. Where it gets a little bit dicey is when you have employees who are given the option to work at home and request to be able to come into the office or come into work, and it's left up to that employee's discretion. I think in that situation, it's arguable that if the employee chooses to come into work, that would be at the employer's direction. But it would be case-by-case basis that you'd have to perform that analysis. The second element is that the day the injured worker worked was on or after March 19th, 2020. Where does that date come from? It comes from the date of the stay-at-home order, which makes sense because prior to March 19th, 2020, everyone was going about their normal business. People were shopping, people were going to the movies, people were gathering in groups. Nobody was at a greater risk than anyone else just because they were working. The third element is that the place of employment worked was not the employee's home or residence. This again makes sense because people such as myself, who are working remotely 100% of the time, are not at a greater risk than the general public just by performing their work. They might actually be at a lower risk because you're just at home. And finally, the last element here is where the first element is satisfied through a diagnosis of COVID-19 rather than a positive test. That diagnosis has to be done by a physician who holds both a physician and surgeon license issued by the California Medical Board, and that diagnosis has to be confirmed by a positive test within 30 days of the diagnosis. So to me, what this says is you have to have a positive test. A diagnosis is not enough. Just because you have a diagnosis does not mean you should automatically accept a claim. You need to wait for that positive test. Now, if you do have all four of those elements satisfied, you will have a presumption that applies, but it's not the end-all be-all. The presumption is rebuttable, which is good for the defense, and which, in my opinion, makes this relatively reasonable as a presumption. If it was a conclusive presumption, that would be a different story. This presumption does also apply for a limited period of time. It applies only to dates of injury occurring through 60 days following the May 6th, 2020 order, which means it applies to dates of injury from March 19th, 2020 through July 5th, 2020. Now, this next part is a little bit concerning and is something that we really want to impress on you very strongly. And this is the fact that the 90-day period, which you normally have to make your decision as to whether to accept or deny a claim, has been shrunk down to 30 days after the filing of a claim form. What that means is that if you do not timely deny a claim within 30 days of the filing of the DWC-1, you have the compensability presumption. That being said, you can rebut it. We'll get into that a little bit more in just a second, but what does the 30-day period mean? It means you need to make a decision as soon as possible, and you need to exercise due diligence in trying to conduct any discovery, because the only evidence you're able to use to rebut this presumption is evidence that was discovered subsequent to that 30-day period, which likely means that any evidence that you could have reasonably obtained within the first 30 days is not able to be used to rebut the presumption. Now, in workers' comp, I'm sure you all know things move somewhat slowly. You're not going to get a deposition within 30 days. You're likely not going to get subpoenaed records within 30 days. You might not even be able to get a recorded statement, because oftentimes you have an applicant's attorney involved who would likely object to that if they're represented. So what we like to do at Rossi Law Group is consider the 90-day period or 30-day period for COVID claims to start as of the date of injury. And then if you make your decision within the first 30 days or 90 days for a regular claim, You're never in the situation where you have an applicant's attorney who tries to argue that a DWC-1 form was provided to the employer day 1, day 3, after a date of injury. So if you can make your decision within 30 days of the date of injury, please do so for COVID-19. And also, we would suggest that you make attempts in writing to obtain the discovery you would need to make a decision, whether that's attempting to get a list of primary care doctors from the applicant's attorney or the injured worker, attempting to obtain a recorded statement during those 30 days, requesting deposition days within the 30 days. Then you can make, you can present to the court good faith attempts to make a decision within 30 days. And then if red flags emerge later on, you can take the depo, you can obtain medical records, etc. after those first 30 days and use any information you get to rebut the presumption. So before we move on to the benefits that are covered by this presumption, I'd like to circle back to a couple of hypotheticals that James posed to you at the very beginning. That first hypothetical, where we have a grocery store worker who, after some discovery, is found to have contracted COVID-19 after or outside of work by that family member who was sick and brought it home to the whole household, that tested positive in April 2020, which is in this time frame that we're looking at here for the presumption. So long as that discovery was found out after 30 days from the filing of the DWC-1, you could use that evidence that the family member presumably worked maybe at a hospital, maybe was in public service as a police officer, something like that, worked at a nursing home, and that's the reason that the injured worker contracted COVID-19. That's one scenario where you would have rebutted the presumption. The other hypothetical, which is the same grocery store worker, there's no evidence that there's a family member who contracted COVID-19 outside of the home at work and brought it home to our applicant. You have no idea where the person contracted COVID-19, but they were working during the time period, had a positive test. That's a situation where the presumption would apply. So as far as what benefits are covered by the presumption, the order itself lays out some of these benefits, including full hospital, surgical, medical treatment, disability benefits, and potentially death benefits if the claim escalates to that degree. That's pretty self-explanatory, no surprises there. One thing that the order does not specifically talk about are things such as temporary housing or special protective equipment. Now, in these cases, I don't think it's completely unreasonable to think that there could be a scenario in which temporary housing would be reimbursable under the presumption. Think of, say, a hospital worker who knows that they're at a higher risk, contracts COVID-19, likely at work, and they have a whole household full of children and a spouse. I think under those circumstances, it could be considered reasonable to reimburse them if they decide to get a hotel room or an Airbnb, assuming, of course, it's not the penthouse suite at the Bellagio, something like that. If it's a reasonable expense, maybe that's something you would want to consider reimbursing. So that would not be overly surprising if some requests like that are made. With respect to death claims, normally, if there is a death without dependents, the state is able to recover those benefits you would normally pay to the family of the decedent. However, with COVID-19 deaths, that's not the case. The state waives collection of any death benefits, which is good. Now to touch on a few special rules regarding temporary disability benefits. The first is that if there are any employers that provide special COVID-19 sick leave, you need to make sure that the injured worker has exhausted that COVID-19 special sick leave before you pay any TD benefits. So in practice, this just means make sure you verify with your employer as soon as you get the claim whether or not they have any special sick leave. I'm not aware of exactly how many employers offer this, but it could be offered, and if so, you don't want to pay TD benefits when the employer could be paying sick leave. If there is no sick leave available, those temporary disability benefits or Labor Code 4850 benefits would start immediately as of the date of disability. There's no 3-day waiting period, and you just go from there. In order to qualify for the TD benefits or 4850 leave benefits, the injured worker has to satisfy one of two different tests. The first is that you have a positive test or diagnosis with COVID-19 on or after the date of that May 6, 2020 governor's order. That applicant has to be certified for a temporary disability within 15 days of the initial diagnosis and every 15 days thereafter for the first 45 days after the diagnosis. Or if the positive test or diagnosis is prior to the date of the governor's order, May 6, 2020, the injured worker has to obtain written certification within 15 days of that May 6, 2020 order, documenting the period that the injured worker was temporarily disabled and unable to work, and they have to recertify again every 15 days thereafter for the first 45 days. The certifications for the temporary disability have to be provided by a physician holding a physician and surgeon's license issued by the California Medical Board. So just double check that every time. The certifying physician can be a designated workers' comp physician as follows. It can be a doctor within the MPN or healthcare organization. It can also be a doctor that the injured worker pre-designated for workers' comp. It can be a physician within the employee's group health plan. And if none of those are available, it can be a physician of the injured worker's choosing, so long as, again, that physician holds the physician's and surgeon's license. Now, James is going to take back over here and talk about a few of the proposed bills that are attempting to make some different presumptions applicable to California claims.
I'm just going to touch on these. We are pretty close to being out of time. The main bill is AB 196, which creates a conclusive presumption that COVID is an occupational disease, basically work-related. And it's for anyone identified as an essential job in the governor's stay-at-home order, which is a lot. And I gave you the example of the grocery store worker in the beginning. Well, grocery store workers are covered. So let's assume that first example I gave you where there was we know it was a family member. This conclusive presumption would say it's still work-related. That's the madness that we're dealing with at this point. So it's very important that we get our voices heard so that we protect our stakeholders from legislation that's ridiculous like this. The governor's order I thought was very reasonable. It had a limited scope. It has a rebuttable presumption. It goes from March 5th or March 19th to July 5th, and then it's done. But this legislation could come in and kick it, to beyond what it should be. And really, we need to have justice here. So it's important that we follow this, voice our opinions, and keep a ridiculous presumption like this from ever existing.
Thank you so much, Elizabeth, and thank you, James. That's a lot of great information to digest. I do have a question for James. He wrote an article that was published last month in the Workers' Compensation Quarterly magazine addressing TTD in light of COVID-19 shutdowns. Can you please discuss your thoughts regarding TTD in light of COVID-19 and advise our attendees how they can get a copy of your article?
Well, I think the article was sent in an email to you, so hopefully if anybody does request it, you can get it. Frankly, TTD could be a whole webinar in itself, so I can't touch on it too much. But what I can say is that there is a solid argument that when an employer was shut down and they were otherwise able to provide modified duty, there's no loss of earnings, and therefore TTD would not be owed. It's a wage loss argument, and it's essentially because the injured workers and the uninjured workers are in the same boat. The only reason they're not working is because of COVID-19 and non-industrial pandemic requiring shutdown. So that's basically it in a nutshell.
Great, thank you so much.
I'd like to have all of our experts join us here on the screen for our final thoughts. I'd like to thank all of you for your contribution to today's MacroPro and Friends. To answer James' question, his article is attached to this presentation, so please make sure that you download it. Again, we need to download everything before the end of the presentation so that you have access to it. So let's go ahead and start with Shandon. Shandon, do you have some final thoughts for us?
No, this is a great session. Just appreciate everybody's time today. It was wonderful. We're seeing some really great results in all states, California and all states across the country with respect to what we do in our services. So I would highly encourage you to reach out, and we'd love an opportunity to assist you.
Great, thank you. James, I know you always have a thought on something.
Well, you know, I do want to say something on the TTD. If anybody is objecting to TTD, they should get it out in writing now. Put the world on notice that you're objecting to TTD, because you don't want to be in a situation where you're paying for 6 months and then you realize that you shouldn't have been because you had an argument that there was no liability, and you can't claim it at that point, because you've got to get everybody on notice. It's like the JCPenney case when you get an AME who goes back a year for your MMI date and you want to try and claim it. Same principle. So get your objection out, file your petition saying you're going to take a credit, and it's a very important thing. It's not in my article, so I just wanted to make sure that you knew that.
Elizabeth, do you have a thought for viewers?
I think one thing, if you're going to take one thing away from the presentation, at least from our office, I would suggest you just write it down, put it on a sticky note by your monitor, whatever you have to do to remember that you have 30 days to issue an acceptance or denial. Don't forget about that, because 90 days is significantly different from 30 days. So make your decision as quick as possible, where possible, and if nothing else, remember that, and stay safe out there.
All right. We did have a question regarding Shandon's segment, and the question was whether or not the films could be obtained by authorization with a WCAB number. So do you want to address that real quick?
Yeah, absolutely. We have actually a few different options for film retrieval. So probably best just to, if somebody has a real specific question, maybe shoot me an email or give me a call. My email address is probably going to be on the contact information afterwards. And I'd be happy to, just run through a specific scenario. But yes, we should be able to obtain films with any medical authorization. Of course, MacroPro and Friends do a phenomenal job, and they're very fast. So keep that in mind, which is one reason we like to partner with them for these things.
Thank you. Graciela.
Just want to thank all our attendees for joining us this morning. Thank you to all the great presenters. Thank you very much. And just to remind our attendees that the certificates are going to be emailed to you tomorrow by mpmeetings@MacroPro. And one last thing, I just want to say happy Father's Day to all the dads out there. So happy Father's Day.
All right. Well, Drew is my co-host. You have the final word.
Well, it was great hearing from everybody. Thank you to all of our presenters. It was awesome. I'd like to remind everybody in the audience about MacroPro's record summaries. If anybody has a large volume of records and they're looking to have them reviewed by a licensed nurse, please reach out to MacroPro. We employ our nurses. We do not outsource like so many other companies. And we look forward to hopefully seeing all of you in the not so distant future in person. But we're glad that we can all participate in this event. So I hope everybody has a wonderful day.
Thanks. So the last thing I'd like to say is if your colleagues were unable to make it today, we do have the same presentation, the same group of the experts will be here again tomorrow at the same time, same place, same station. So we will see you then. And we hope soon we will see you face to face. Have a great day and stay healthy. Bye-bye.
Bye, everyone.
Bye-bye. Nice job, everyone.
Thank you. Great job.